What's up, everybody? We're back at it, back home, safe travels, great trip. You guys got to come along on the journey with me a little bit on Instagram and Twitter, but this was by far the most asked about thing today from me, and that was the Sarah Boone hearing. It's a status hearing. We figure out where we are, if we have any updates, if we've made any movement towards getting that expert and getting funding. The trial's being pushed. How far will it be pushed out? Do we have a new trial date? Do we think it's going to go that date? All of those questions and more will be answered in this video. So if you guys are still interested in the Sarah Boone saga and everything that's going on with this case and this trial and all of the delays and all the lawyer issues and even some judge issues potentially, hit that like button and subscribe to our page and hit that reminder bell. Let's jump into this hearing. We're going to watch it together, react to it together, so that we can see if we can try to figure out what's going on and when this case is going to get to trial. So she's talking with her lawyer, no microphones. Seems like everything's fine. I wouldn't say it looks like the best relationship in the world, but it doesn't seem like any major issues. Doesn't seem like she's ignoring him. He's not yelling at her. No major issues like that.
It was returned to me because none of you boxes were checked. Are they
Trial, pre-trial, entry, please.
The voices you can hear, I think, are the JA and the judge, or the clerk and the judge.
whatever. State of Florida versus Sarah Boone, 2020 CF 2603. Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give should be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
So what's interesting is they swear her in. And the purpose of this and why we do this in these situations with criminal defendants is she's not testifying, but anything she says in open court today and on the record is under oath, can be used against her. Any statement, of course, made by the defendant is a party opponent, an exception to hearsay. So it's going to come in. This is just a formal way of swearing her under oath so that it puts a little added pressure that whatever you're going to say needs to be the truth here in open court. What will she say? Let's find out.
Good morning, ma'am. Tell me your name and your date of birth.
Sarah Boone, 10-10-77.
All right, we're here for status hearing on your case. Your case was set for pretrial conference back on July 12th, but as I promised you, I was going to bring you over, so whatever the things that we normally discuss at pretrial would be discussed while you were present in the courtroom. Mr. Banquets, in court, you previously discussed an issue with getting JAC to pay your expert. I'm going to just paraphrase for this battered spouse defense.
And they have filed a formal objection, which now has been set for hearing. I want to say September the 18th, first available time, because they have to have.
So I'm going to back it up. He said they have filed a formal objection. I think that means the JAC, because if it's the state objecting to this expert, that would be unusual because I think the state's already okay with it and they've kind of gotten their expert, but the JAC seemingly does not want to pay for this. Now, there could be a lot of reasons for that. One of them could be maybe they don't think that this makes any sense because they waited so many years to even bring this forward. That's unusual. Maybe the cost is too high. That also seems weird since Banquet said this expert has been within the ranges that they've paid before and testified, it seems like, on behalf of public defenders and court-appointed lawyers in the past. So it's kind of strange. I'd be interested to see on why the JAC is objecting to this. I'm going to back it up so we can hear when that hearing date is.
I'm going to just paraphrase for this battered spouse defense.
And they have filed a formal objection, which now has been set for hearing. I want to say September the 18th, first available time.
So the quote unquote first available time for this hearing to hear their objection is not until September 18th. September 18th, folks, that is 2 months away. So nothing can really happen. This is their main defense. They can't prep with their witness. They can't talk to their witness. They can't get a report. They can't have this expert interview Sarah Boone because they don't know if they're going to pay her or how they're going to pay her. So literally nothing can happen on this battered spouse syndrome defense for 2 months. So that means we're for sure not having trial in July, in August, or in September. So the delays continue for Sarah Boone. Now, there's a lot her lawyer can be doing, prepping other witnesses, reading all the depots, prepping with Sarah Boone about what their strategy is going to be on cross, how they're going to do this. Are they going to admit that she put him in the suitcase on purpose? Because usually for battered spouse syndrome, you have to admit the facts of the crime. But in this situation, she could say, she was too scared to let him out of the suitcase, and that's where the battered spouse comes in, I think that might be an okay argument. I don't think it's going to work because of all the other context and videos and statements that she's made. But just if I'm speaking in a vacuum, if you do something and then don't undo it because of fear of how your partner will react based on them beating you in the past, I think that could potentially fit into the battered spouse syndrome defense. But again, we can't know any of that. We can't prepare any of that as Sarah Boone's team, her lawyers, speaking as them for now. They can't do that while they're waiting to see if it's even get paid for. And then let's assume that they say, yes, okay, we're going to pay for it. Or they lose on their objection on September 18th. It's not like tomorrow you can have trial. We'll talk more about that when we hear what the trial date is that the judge sets.
Because they require 20 days for hearing purposes, and we couldn't get on your docket before that date.
All right. So, Mr. Cacciatore, Ms. Boone's present. Mr. Banquets is asking to continue the case so that we're going to have a hearing with JAC on his request for funding for a defense expert. Given my understanding of the case, that defense expert would be crucial to at least one defense that's going to be offered in case.
You can see where this is going, right? Yet another continuance. The state can't really object. What are they going to do? Say, judge, we object. Let's get the state to trial. It's the defense that really should want this case to go to trial. The state's not going to object and then have an appellate issue that they weren't allowed to get the one and only main expert of their entire defense. So the state does the right thing, doesn't object. So the court's going to continue the case. That's just how it works. We're learning how important that speedy trial is.
And my understanding is you can't do anything until that expert actually is identified as a witness who's going to be called, correct?
That's correct.
Meaning the state can't depose this expert. They can't have their expert look at their reports. They can't interview Sarah Boone themselves. They can't pick apart how the expert did, like we saw in Letitia Stock and other cases. They can't do any of that until obviously the expert is paid and does their work for the defense. Then the state gets to depose them, respond, get a reply report kind of deal going. But again, the defense has to do all their work first.
I understand, but it's not unknown at this point whether she's going to be called. And I assume since there's no agreement as to payment, potentially there's going to be an issue with the state deposing her at this point in time.
Right.
So that's what I meant by he can't do anything until you get to the bottom of what she's going to be paid and whether she's willing to formally accept the case. Is that a fair statement?
Semi-fair. She is formally willing to accept the case. The issue is the hourly rate. JAC has changed their hourly rate for this area of expertise for over 10 years.
So
this witness will accept the case. It's not like she doesn't want to work with Sarah Boone. It's not like she doesn't want to work with Bankiewicz. She will accept the case. It's the JAC and changing of their hourly rates for this type of expert, I guess, is what they're dealing with. They're going to, I'm sure, argue that there's just not enough money to do this. It's too expensive. He's got to find a cheaper expert, whatever it may be. I'm sure we will watch that hearing together if it's live streamed. I'm sure Sarah Boone will want to be there since she wants to be there for everything, and that is her right. So this is probably something we will learn more about as we maybe see the objection come through or watch the hearing together.
Mr. Cacciatore, the request is to continue so that issue can be resolved. Do you have any objection to that?
No, Your Honor.
All right. I'm going to grant the request to continue under the circumstances.
Frankly, Sarah Boone should be happy with that, right? Her best chance to win, as far as her lawyer thinks, and I'm assuming she agrees with this point, is the battered spouse syndrome defense. You need an expert for that. If the court would not have continued the case, she would probably be upset about that. So she needs to get the case continued so that she can get her expert paid by the state.
What's the hearing date that we're currently working with, Mr.
I want to
Banks?
say September the 18th, Judge.
That sounds like what my JA told me as well. For control purposes, I'm going to set the case for my September 20th pretrial, October 2nd trial period, with the understanding that we can address.
So September 20th pretrial, which is 2 days after the hearing. Impossible that anything gets done with those 2 days, especially if experience tells us anything with this case and the moving parts and people in this case. Number two, it's on the October 2nd trial period. 0% chance, and I mean a big fat 0% chance this case goes to trial on October 2nd. There's another little trial that might be happening on October 2nd. Also unlikely, but this is even less likely. This case is not going to trial in October. I can almost guarantee that, if they really can't do anything or get any payment to this expert until September 18th. That is an impossibility. I don't think this trial is happening in 2023, unfortunately. Maybe December. I hope it does. It seems like the defendant wants it to go. It seems like the state is ready. I hope they can get all their ducks in a row and get this case tried. I feel like it's feeling more like an early 2024 trial, unfortunately, for everybody, but that would be my guess at this point. Again, no chance October 2nd, maybe end of the year, November, December, if everything moves quicker than it normally does and quicker than it has in this case. But this judge likes to set trial dates and pretrial as placeholders as if it's going to put more pressure on the defense or the prosecutors. It has not worked thus far as they keep coming up with reasons for continuances, and he doesn't really have a choice but to continue them, especially when the defense is asking for them at this point and they really need them. We are going to hear a little bit from Sarah Boone here at the end.
Essentially address pretrial. And I understand that you're unlikely to tell me that you're ready to try this case on October 2nd, regardless of what happens to the 18th.
Correct.
But I just want to have the case scheduled close in time to the 18th so we can address them at the same time.
Thank you, Judge.
All right.
Have a good
That
day.
is the order of the court. Ms. Boone, you'll be returned to the Orange County Jail while Mr. Banquet continues to prepare your defense. All right.
Judge Boone,
Thank you, Judge. Have a good week.
Hold on one second. Ms. Boone, I've addressed pretrial. I brought you over.
So I'm going to back it up so we can hear this again. You tell me what you hear in the judge's voice, because I hear, I've had enough of it. I don't want any more of it. I don't want to hear what you have to say. I have addressed the issues that you have a right to hear. You do not have a right to have discussions in open court and arguments yourself while you have a lawyer, which is all true and correct. So he seems annoyed to me right off the jump, but he does end up letting her talk. I'll back it up so we can just kind of hear the tone in his voice again.
County Jail while Mr. Banquet continues to prepare your defense. All right.
Judge Boone,
Thank you, Judge. Have a good week.
Hold on one second. Ms. Boone, I've addressed pretrial. I brought you over. I'm going to give you a moment if you want to share something else with me, but that's what I needed to address today. And I've got other matters that I need to address in short order. So
I understand, and I'm grateful for your time. I had previously sent you a letter, and it has not been uploaded, but it was made an announcement to the courtroom during my pretrial that you do have it, and I was wondering why and if it will be uploaded, because I have another copy of it that I would like to hand deliver to you today.
So I don't know if this is a letter we've already read or have not read yet. What she's about to hand him seems like kind of a thick stack of papers for a letter that maybe we haven't read yet. She also says she revised it. So if there's an updated letter for us to read, we will read that together, talk about it, see what she's saying, see what she's complaining about, see if it's legitimate or if it's kind of the same stuff or illegitimate and, sour grapes or whatever it may be about the media and things like that. Or if she has legitimate concerns about delay or people not talking to her or not working on her case, as is her right. So I don't know if we've read this letter yet. If you guys get your hands on it, of course, send it to me as always, and I'd be happy to break it down and read it with you. The judge does allow her to hand deliver it, copy it, and give her a copy.
why it has not been uploaded. I'll have to talk to my JA about that. If you want to give me another copy, that's fine.
Yes, please.
All right. Go ahead and just tender it to one of the deputies. And actually, any objection if I just have the clerks scan it here in open court?
Yes, please. And do I normally get a copy? I haven't gotten one. I'm sorry.
Well, it'll be filed in the case.
If it's uploaded, Judge, I can make it.
It's a lot of paper.
Okay. All right.
Yes, please. If that would be okay, I would like to have that one uploaded. It's revised.
Okay.
From the judge's perspective,
And, what I had directed
it's
my-
not worth it to argue with her or say we already have it or not. Just go ahead and upload it. What does it matter? Upload it, give her a copy, and let's move on. Let's keep it moving.
Judicial assistant was to disclose this to the attorneys. Again, to a great extent, when I read.
And again, it's disclosed to all the attorneys because if it's part of the case file, it becomes public. These are her statements that are public, which is why judges don't really want defendants to do this. When they're represented by counsel, they have a right to remain silent. They are represented. They can talk through their counsel. Their counsel is supposed to be their mouthpiece in court. This isn't obvious to me loss of faith in your attorney as Sarah Boone doing all of this. But when you can't afford to choose your own attorney and you're unhappy with basically every attorney you get, the system can only do so much for you when you are that kind of criminal defendant. So the judge is, again, trying to do his best to make her aware of her rights and warn her, but she is going to continue to write letters and say things in open court that can potentially be used against her in the future.
Original, you've covered a great deal of ground that we've covered in open court on multiple occasions about the method and manner of communication. Having read the original letter, I did not believe there was any additional action that I needed to take, which is why I didn't take any action on that letter. All right?
By the way, if you're wondering, what could they possibly use about her complaining about the media or complaining about her lawyers not talking to her from her letters? Well, one thing just off the top of my head, I haven't really thought about this. If this was my case, I'm sure I could think of multiple ways to use these letters. But one of them I might say is, isn't it true you wrote 27 letters to your lawyers and the court in this case, and they've been uploaded to the court file if she takes the stand? Yes. And not once in these 27 letters did you ever mention battered spouse syndrome. Not once in these letters did you ever mention this or that or whatever that you're trying to argue now 3 years later. You better believe that when this, if and when this expert evaluates her, they're going to say you evaluated her here years after the event. So that type of stuff, people are annoyed in the chat, and I understand they're annoyed that she's bringing up this defense so late in the case. It does happen from time to time, but the jury will find out about the timeline, when these complaints started, if it's legitimate, if it was happening at the time of the crime, because that's what's important. So again, these letters can come back to bite her potentially if the state decides that there's something useful in them.
So to be filed, Ms. Boone will be returned to the Orange County Jail pending further order of the court.
Thank you.
You're welcome.
And that's all she wrote for this hearing. If you guys have any more questions, let me know in the comments, and I will look through them. We'll continue to answer them as we go on. This case is not going to trial anytime soon. No shot it goes to trial in October. I would say the earliest is in December, more likely early 2024 for a case that was supposed to be tried in early 2023, was supposed to be somewhere I traveled to after hitting 200,000 subscribers. It is still on the list to travel to, but who the heck knows where we'll be at that point and time. But thank you for sending this to me. Thank you for joining me. As always, you guys are the best. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.